Switzerland didn't lose the offshore war. It sold the blueprint before the walls came down. That distinction matters. Losing implies defeat. What actually happened was a controlled liquidation of a monopoly position, executed over roughly 2 decades with characteristic precision by the same institutions that built the monopoly in the first place. The assets moved, the architecture migrated. The brand absorbed the regulatory pressure and converted it into a different kind of leverage. What looked like surrender from the outside was, structurally, an exit at near-peak valuation. Start with the foundation. Article 47 of the Swiss Banking Act, 1934. That single provision made it a criminal offense, not a civil infraction, a criminal offense, for a Swiss banker to disclose client information to any third party, including foreign governments. The official story frames this as a response to Nazi Germany's attempts to identify Jewish assets held abroad. That framing is partially accurate and almost entirely convenient. The law did protect some Jewish depositors. It also protected the Nazi regime's own capital flows through Swiss institutions. It protected French industrialists, Italian politicians, and South American oligarchs with equal institutional indifference. The law wasn't designed to protect victims. It was designed to protect the jurisdiction's competitive advantage. The Nazi pressure provided the political cover to codify what Swiss private banking had already been practicing informally for decades. What 1934 actually built was jurisdiction as product. Switzerland wasn't offering banking services. It was offering a legal environment, a carefully engineered sovereign space where the normal rules of financial transparency simply did not apply. Clients weren't buying access to competent investment managers. They were buying the absence of accountability. The numbered account, the anonymous structure, the discretionary trust. These were delivery mechanisms for a single underlying service, the formal, legally enforceable right to make your money invisible. The peak of that product's market dominance ran roughly from the 1960s through the early 2000s. By the mid-90s, Swiss banks were managing an estimated $2.4 trillion in offshore assets, a figure that represented a substantial fraction of all privately held cross-border wealth globally. UBS, Credit Suisse, Julius Baer, Pictet. These weren't simply large banks. They were the institutional infrastructure of a parallel financial system that existed specifically to serve capital that preferred not to be observed. The fees for that service were extraordinary, and the clients paid them without complaint, because the alternative, visibility, cost more. During those decades, Switzerland absorbed assets from virtually every category of political and financial embarrassment available. Ferdinand Marcos moved an estimated $10 billion through Swiss accounts during his tenure in the Philippines. Jean-Claude Duvalier, Baby Doc, parked Haitian state funds in Geneva while his population starved. The accounts of Holocaust victims, Jewish families who had deposited assets in Swiss banks before the war and then died in concentration camps, sat untouched for decades, their existence denied by Swiss institutions until a 1998 World Jewish Congress settlement forced a $1.25 billion reckoning. The pattern across all of these cases is identical. The architecture performed exactly as designed. It held assets in silence. It asked no questions. It released nothing voluntarily. That is not a scandal. That is a product specification. The controlled demolition began not with European pressure or international shame campaigns, but with a single American banker who decided his immunity deal was worth more than his discretion. Bradley Birkenfeld was a UBS private banker who, in 2007, walked into the United States Department of Justice and explained in precise operational detail how UBS had spent years helping American clients conceal assets from the Internal Revenue Service. He brought names, account structures, and methodology. The DOJ, which had been circling Swiss banking practices for years without sufficient leverage, now had both. In 2009, UBS paid $780 million to settle criminal charges and handed over 4,450 American client names, the first forced breach of Swiss banking secrecy in the law's 75-year history. Birkenfeld received a $2.5 million whistleblower award and served 30 months in federal prison, which is the kind of outcome that clarifies institutional incentives very efficiently. The UBS case was the breach. What followed was the demolition. FATCA, the Foreign Account Tax Compliance Act, passed in 2010 and required foreign financial institutions to report American client holdings directly to the IRS or face a 30% withholding tax on all U.S. source income. This was not a negotiation. It was a structural ultimatum: participate in American financial surveillance or be severed from dollar-denominated markets. For institutions with significant U.S. exposure, the choice was straightforward. Switzerland complied. The OECD's Common Reporting Standard, finalized in 2014, extended the same logic globally. Automatic exchange of financial account information between over 100 jurisdictions, eliminating the bilateral negotiation that had allowed secrecy jurisdictions to stall for years. Switzerland signed. The architecture that had taken 80 years to build was formally dismantled in approximately 5 years of coordinated regulatory pressure. But here is the part that gets omitted from the official narrative of regulatory triumph. Switzerland didn't dismantle the architecture. It transferred it. The legal frameworks, the service culture, the structural logic of jurisdiction as product, all of it migrated, in the years immediately preceding and following FATCA, to jurisdictions with less institutional history, but equivalent functional capacity. Dubai's DIFC, the Dubai International Financial Center, operates under English common law inside a UAE civil law system, creating a legal enclave specifically designed to offer international capital a familiar, flexible environment. Singapore tightened its regulatory presentation while simultaneously deepening its private banking infrastructure for Southeast Asian and Chinese capital. The Cayman Islands, already the world's dominant hedge fund domicile, refined its fund structures for the post-FATCA era. Delaware LLCs and Wyoming statutory trusts provided American domestic equivalents of what Swiss numbered accounts had once offered. Beneficial ownership concealment at a jurisdiction that faces no foreign reporting pressure because it is the foreign pressure. And then, crypto arrived, speaking the language of decentralization but operating on the same ancient logic. Find the space outside the reach of the accounting. The specific technology is new. The demand function is not. Credit Suisse collapsed in March 2023. Absorbed by UBS, in a government-brokered rescue that valued one of Switzerland's oldest institutions at 3 billion francs, a fraction of its stated book value. The coverage framed this as a failure. It was, more precisely, a confirmation. Credit Suisse had spent years accumulating operational disasters. The Archegos exposure, the Greensill collapse, the succession of risk management failures, because the core value proposition that had once made Swiss private banking structurally irreplaceable had already been distributed elsewhere. The moat had been filled in. What remained was an institution running on legacy reputation without the underlying product that had created that reputation: When the institutional logic of a business migrates, the building that used to house it becomes expensive real estate. The pattern here is not unique to Switzerland. It is the standard operating behavior of any monopoly facing structural disruption. Extract maximum value from the existing position, negotiate the terms of the transition, ensure the successor architecture reflects your intellectual contribution, even if it no longer carries your name. The Swiss financial establishment spent the 2000s doing exactly this, not fighting the inevitable opening of their books, but managing the timeline and ensuring their private banking expertise found new institutional homes in jurisdictions they had already begun quietly cultivating. What that pattern reveals, stated plainly, is this: the demand for a place where capital escapes accountability is not a product of any particular legal system or political culture. It is a permanent feature of the relationship between concentrated wealth and the states that try to tax it. Switzerland didn't create that demand. It merely served it with exceptional elegance for an exceptionally long time. When the service became untenable in its original form, the demand migrated, as it always has, as it always will, to wherever the architecture was most recently refined. The system was never Swiss. Switzerland was just its most successful address.